Business organizations, agency. Agents representing principals to third parties. Agency is a three-party relationship whereby a principal appoints and authorizes an agent to engage with a third party on the principal's behalf. The principal is bound by the agreement negotiated by his agent. The agent has a duty to perform with loyalty, reasonable care, and cannot self-deal. Agency can be formed by contract, but is not necessarily contractual. The body of law governing agency derives from common law and is summarized by the Restatement of Agency, currently in its third edition. Agency law is state-based and not controlled by federal statutes. However, there are of course federal statutes governing aspects of employment law which involve agency relationships. Agency concepts are inherent in partnerships, corporations, LLCs, and other business organizations. An agency relationship is created by agreement between the principal and the agent. It requires consent. An objective standard is applied to determine if the principal and agent expressed a mutual manifestation of intent to form an agency. A writing is not usually necessary. An agency can be formed verbally. However, as we'll see later, the Statute of Frauds does require written agreements in real estate and certain other transactions. The agency can be formed by express agreement, providing the agent with actual authority to act on behalf of the principal. An implied agreement can also form an agency. For example, when an individual represents a company as CEO, an agency relationship is implied, and the CEO title implies authority to bind the company to agreements usually made by a CEO. The agency can be created by the principal alone when the principal leads a third party to believe the agency exists, that an agent has authority to bind the principal. Although the purported agent may not be party to an agency agreement with the principal, the agency is created when the principal leads a third party to believe the agency exists, and the third party reasonably relies on such belief. The purported agent here has apparent authority created by the principal. If an agency relationship does not exist, it can be later created by ratification, if the principal accepts the benefits or affirms the actions of an unauthorized agent. For example, if an art dealer finds a piece of artwork, represents to the seller that the dealer is acting as agent for a principal, and negotiates to acquire the artwork on behalf of the principal, the agent can later approach the principal and offer him the opportunity to ratify the previously non-existent agency and acquire the artwork. As we will see, this is a risky endeavor, as the purported agent can be bound to buy the artwork himself if the principal does not later choose to ratify. Although formation of agency is usually consensual, a contract is not necessary for an agency to form. Unlike a contract, consideration is not necessary to create agency relations. The agent can be appointed without any form of barter or payment. Contract and agency are similar in the way the law uses an objective standard to determine their existence. In both situations, the court asks whether a reasonable person under the circumstances would believe the agency or contract exists. If a reasonable person in the shoes of the agent would believe he had authority to act on behalf of the principal, based on the acts of the principal, the court determines the agency was formed. Contract and agency are both subject to the Statute of Frauds. A writing is required for real estate and other transactions triggering the Statute of Frauds. Both contract and agency relations are invalid if formed for an illegal purpose. Capacity is slightly different in contract and agency law. Capacity is required in both contracting parties, but only in the principal under agency law. The agent can lack capacity, so it may not be possible to form a binding contract with a child, but it is possible to appoint a child as an agent, and the principal will be bound by the agreement formed by the child and the third party. So, if a child runs an errand to a store for her parent and purchases goods on credit, the parent is liable to pay the debt to the storekeeper. Punitive damages are not available in breach of contract cases, but they are available in tort. So a breach of agency duties leading to injury can trigger a claim under tort law that could lead to punitive as well as compensatory damages. The principal has duties to the third party and duties to the agent. The essence of agency law holds that the principal is bound to perform the duties agreed with the third party via the agent. The principal owes the duties of care, cooperation, and compensation to the agent. The principal owes a duty of care to everyone, including his agent. The principal can be liable for negligence harming the agent or harming anyone else. The principal's duty of care is most apparent in the employer-employee setting. The employer principal has a duty to provide a safe workplace environment for the employee agent. The principal's duty of cooperation essentially restricts the principal from preventing the agent performing his duties. Of course, the principal also owes a duty of compensation. This requires the principal to pay the agent's fees according to the understanding between agent and principal when the agency was formed. If the principal breaches his duties to the agent, the remedies available from the court include compensation for losses incurred by the agent and authorized sub-agent. If the agent holds property belonging to the principal, a lien can be placed on the property and can be foreclosed, selling the property to satisfy the debt. Specific performance is not a remedy available to agents for breach by principal. The principal can be forced to pay compensation, even punitive damages in tort cases, but cannot be forced to perform a specific act. So, a real estate agent representing a seller cannot force the seller to go ahead and sell his house. The real estate agent could be compensated by money damages, but the principal cannot be forced to specifically perform by selling the house. The agent owes duties to the principal. The agent has a duty to notify the principal of significant information. So an agent engaged to sell property for a principal has a duty to inform the principal of offers the agent receives for the property from third-party buyers. Of course, the agent has a duty to perform the tasks forming the purpose of the agency, and is required to take reasonable care in the performance. The agency relationship places fiduciary duties on the agent. The agent is required to act with loyalty to the principal. This generally means no conflicting interests. The agent must act selflessly, entirely in the interests of the principal. The agent cannot compete with the principal or engage in self-dealing. So an agent selling a house for a principal would breach his fiduciary duties if he were to attempt to buy the house for himself. When the agent acts for a partner or another principal, this is known as dual agency. The agent representing a buyer as well as a seller is required to disclose the agency to each party. A real estate agent is a good example of a broker representing several clients at the same time. One agent can represent several buyers or several sellers. The agent representing multiple competing principals must disclose the multiple agencies and segment the activities to ensure that loyalty to any one principal is not compromised. Where the agent breaches his duties to the principal, several remedies are available from the court. Compensatory damages are available as they are in breach of contract. Punitive damages can be available under principles of tort law where the breach of fiduciary duty was done with malice or bad faith. The agent is acting for the principal, and usually the agent has no duties to a third party. However, there are exceptions. When the purported agent lacks authority, the purported agent, not the purported principal, is liable to the third party. So, if the agent places a bid to purchase property telling the seller, "I'm acting as agent for my client," but the agent is unauthorized by the client to bid on the property, then the agent is liable to complete the bid and the agent himself liable to purchase the property from the third party. This first exception involves an agent claiming to represent a principal but lacking authority to do so. The second exception is the opposite, where the agent claims to represent himself but is in fact acting for an undisclosed principal. Here, the third party can hold the agent as well as the undisclosed principal liable to fulfill the agreement. The same is true in the case of the partially disclosed principal. The agent says he represents the principal, but the identity of the principal is not disclosed. Where the agent represents an undisclosed principal or a partially disclosed principal, the agent can be held liable to the third party, but may have indemnification from the principal. Like anyone else, an agent is able to appoint his own agents. These are known as sub-agents. In fact, chains of agency are very common in business organizations. The sub-agent has the same duties to the principal as the agent. The agent is also liable to the principal for a breach of duty by his sub-agent. The principal has a duty to compensate the agent, but is under no duty to compensate sub-agents. A common example is where a client principal engages a company as agent and the company hires employees. The employees are sub-agents to the client principal. The employees have duties to the client principal, but the principal owes no duties to the agent's employees. The agent company is liable to pay its employees, and the employees cannot demand payment from the client principal. Respondeat superior, translated from Latin, means "let the master answer" for the acts of the servant. The principal employer has responsibility for the actions, omissions of her agent's employees when they act within the scope of the agency employment. Respondeat superior is a form of strict liability and cannot be waived. A third party injured by negligence of an employee driver can look to the driver's employer for compensation if the incident took place while the employee was on company business. The employer is not liable where the employee was running a personal errand when the collision took place. Respondeat superior applies to employer-employee relationships. The employer principal is liable for the acts of the employee agent, but not usually liable for acts of independent contractors. The distinction is control. The employer is able to control how the task is completed by the employee, but does not control how independent contractors perform the tasks. Generally, the independent contractor is independent, and not under the control of the employer. An exception involves a situation where the independent contractor is not in fact independent, and to all intents and purposes operates like an employee. Placing an independent contractor label on what is really an employee under the control of the employer does not relieve the employer from liability for acts of the mislabeled employee. The employee is an agent of the company and has authority to bind the company to transactions and agreements within the scope of the individual's authority. When a third party enters a contract with a company, the question often arises as to whether the employee signing the contract has authority to bind the company. Authority can be provided to the third party explicitly, or it can be implied. For explicit authority, the third party must confirm with the principal, the company, that the employee has sufficient authority to bind the company to the agreement. One of the most reliable forms of explicit authority involves written confirmation by the company's secretary or senior officer. Note that the confirmation constituting explicit authority is provided by the company, the principal, not by the employee agent. A statement by the employee signing the contract stating, "Yes, I have authority," is not as compelling as a statement from the company secretary or CEO stating that the employee has authority. Explicit authority is not always necessary. An employee with the title of CEO or President implies authority to bind the company. As discussed on slides on authority under corporate law, the authority of the CEO or President covers matters within the ordinary course of business of the company. The CEO may have implied authority to bind the company to a supplier agreement, but this implied authority may not extend to matters outside the scope of the CEO alone, such as agreements to sell the whole company. When it comes to these extraordinary decisions, the CEO is usually unable to act without approval from the board of directors and the shareholders. Where the implied authority of the employee signing the agreement is questionable, third parties often seek explicit authority from the company to ensure that the company is indeed bound. The existence and identity of the principal is often hidden from the third party by the principal. The principal is partially disclosed in the situation where the agent tells the third party, "I'm representing an anonymous principal." The principal is fully disclosed in the situation where the agent tells the third party, "I'm representing myself." The third party does not know the identity of the principal, so is able to hold the agent liable. An agent for an undisclosed or partially disclosed principal is liable to the third party, and so is the principal. In situations involving agreements formed by agents acting for undisclosed principals, the third party has a right to rescind the agreement. The third party believes he is contracting directly with the agent and is often surprised to find the agent is acting for an undisclosed principal. The third party has a right to rescind the agreement. The same usually applies in situations involving partially disclosed principals. There is an exception where the agent is acting gratuitously. An agent that's uncompensated by the principal can be held liable to the third party, but can claim indemnification and recovery from the principal. The agent for the undisclosed principal can be held liable to the third party, but can also ask the court under its equity powers to force the principal to pay the agent quantum merit, what the agent's work was worth, when the principal accepted the benefits of the agent's work. Dual agency exists when the agent represents both parties. A dual agent may have two concurrent agency situations representing the buyer and the seller in the same transaction, and must disclose the arrangement to both principals. Otherwise, the transaction is voidable at either the buyer or seller's option. An undisclosed dual agency represents a breach of the agent's duties of loyalty to his principal. The dual agent clearly has a conflict of interests. As buyer's agent, he usually has a duty to negotiate the lowest possible price. but as seller's agent he's usually bound to negotiate the highest possible price for his client. In a real estate transaction, a single agent often interfaces with both buyer and seller, but there's no special exception for real estate agents. The agent representing one party is able to communicate with and assist the other party to a real estate conveyance, but is restricted from representing both sides as agent in the same transaction, unless he provides full disclosure to each. The agent for the seller can advise the buyer, but the agent's duty of loyalty remains with the seller. There are several ways to terminate an agency. Explicit termination can be achieved by renunciation or revocation by either the agent or the principal. As we will see on another slide, the agency is automatically terminated by the death of the principal or the death of the agent. Incapacity can terminate the agency if the agent is rendered unable to perform her duties. An agency formed with a specific term will automatically terminate on expiration of the term. If there is no term, the agency expires after a reasonable time. The agency can come to an end when its purpose has been accomplished, even if accomplished by the principal or another party. So an agency created to sell a house will expire at the moment the house is sold, regardless of whether the house was sold by the agent, the principal, or someone else. Likewise, the agency expires if the house burns down. Such a change in circumstances can terminate an agency arrangement. Termination of an apparent agency often requires notice to the third party. A third party's supplier to a company principal, believing the corporate employee holds authority to bind the company, requires notice from the company principal that the employee agent no longer holds the requisite authority to terminate the agency. The agency is terminated in this situation when the company sends notice to the third party. Notice can be in the form of a personalized letter or perhaps by public advertisement. Of course, apparent agency is also terminated by death. Death of the principal terminates the agency. The principal cannot be bound to agreements formed by his agent when the principal is dead. An agent on assignment to purchase property for a principal can negotiate the transaction with the third party, only to find that the principal died before the transaction was formed. The agent runs the risk of being liable for purchases and commitments made on behalf of his dead principal. There are some exceptions. A bank acts as agent for its clients and is allowed to settle checks written by the client up to 10 days after his death. Another exception applies when the agency was formed with consideration. If the agent provides some form of consideration to the principal in exchange for the agency engagement, the principal's estate can be bound to agreements formed by the agent after the principal's death.